Hello, everyone. So, this is going to be the lecture podcast on the week 5 topic on the separation of judicial and non judicial powers. And at the end of the topic, you should be able to identify, distinguish, and explain judicial and non judicial powers. You should also be able to explain the separation of Commonwealth judicial and non judicial powers. And then cite and discuss key judicial decisions that elaborate on the notions of judicial and non-judicial powers and the separation of Commonwealth judicial and non-judicial powers. Let's begin by talking about why we bother to make a distinction between judicial and non-judicial powers. The first reason is that the High Court has been very vigilant against allowing the legislature or the executive to encroach into the federal judicial powers. So the High Court will not tolerate any attempt on the part of the legislature or the executive to vest a tribunal or an agency or board or body with judicial powers. And that is because, especially in the context of the Australian Westminster parliamentary system of government, as we already previously noted, the legislature and the executive, as constituted, for example, by the Prime Minister and his cabinet ministers, they form part of the legislature. So there is, to a great extent, already a partial separation of the powers of government, which is unlike that, for example, in a presidential system of government, such as in the United States, where the executive, headed by the United States of America president, and the legislature, composed of the Senate and the House of Representatives, and the judiciary, as headed by the Supreme Court, they are distinct from and separate from each other. So they are able to act as checks and balances on each other. But in the context of the Australian Westminster system of government, because of the fusion of in a sense, of the powers of the legislature and the executive, it falls to the judiciary to kind of protect the bulwark of democracy and constitutionalism by disallowing an agency which may actually be part of the executive from exercising judicial powers. Because, as we also previously noted, where you have a situation where a body or instrumentality has the power to make laws and then the power to enact laws, and then it also has the power to actually determine whether the law is valid or not, what you have is a despotism or an autocratic body or agency, which is therefore above the law because it is able to determine whether or not its own actions are legal or not. And so the High Court will not tolerate it. In fact, if you go by the case of the Boilermakers case, there are two key propositions that the High Court said in that case. And the first is that it will not allow the vesting of Commonwealth judicial power in non-Chapter 3 courts. And secondly, it will also not allow the vesting of non-judicial power in Chapter 3 courts. As previously noted, when we speak of Chapter 3 courts, these are courts that are constituted according to Chapter 3 of the Australian Constitution. And in particular, judges which form part of Chapter 3 courts are therefore insulated from a lot of political pressure and influence, mainly because they have security of tenure. They cannot be removed from office, except, for example, under Section 72, by the Governor General in Council on address from both houses of the Parliament, and where he makes a prayer that such removal be on the ground of proven misbehavior or incapacity. And their appointment also has to be by the Governor General in Council, and the remuneration also is protected in the sense that Parliament is not permitted to diminish their remuneration during their continuance in office. So the Chapter 3 judges are heavily insulated as well from political pressure, whereas people who are part of non-Chapter 3 courts or tribunals, they don't have security of tenure, and there's always the possibility that their remuneration will be changed, and even their appointment will be subject to the pleasure and the confidence that the executive may have in them. So that's one. But the other reason why we seek a distinction between judicial and non-judicial powers is that it is often the case that we come across institutions of government, and mainly these are in the form of administrative tribunals, that exercise quasi-judicial powers, or they may actually be acting like courts. So if you look at, for example, the Administrative Appeals Tribunal, that is not a Chapter 3 court, although it acts judicially. And it makes you wonder, therefore, how is it possible that a body which is acting judicially, such as the AAT, is permitted to operate and has been validated to be by the High Court to be a valid institution as part of the executive, even though it seems to be acting judicially. And the reason for that is that whilst an administrative tribunal such as the AAT may be acting judicially, it is not necessarily a Chapter 3 court. And when we speak of the notion that an administrative tribunal is acting judicially, we actually mean that in two senses. One is that it acts according to natural justice, in the sense that it typically gives persons who appear before it, or corporations that appear before it, the opportunity to be heard. That's one. But the second aspect is that the judges who form part of the tribunal are expected to act fairly and impartially. So they are not permitted to discriminate. They are not permitted to use subjective standards. There are objective standards that they must follow, whether that be based on policy or even if that may be based on discretion. So that's the reason why we have to look into this, because oftentimes Parliament may enact a law creating a body. And Section 77, for example, and Section 72 authorizes the Commonwealth Parliament to actually create Chapter 3 courts. But Parliament itself, within under Section 51, also has the power to create tribunals or bodies that may appear like courts, but actually are not Chapter 3 courts. And therefore, you need to determine whether or not those new bodies that Parliament may create, not on the basis of Chapter 3, but on the basis of its legislative powers under Section 51, you need to determine whether or not those bodies or boards or tribunals are actually Chapter 3 courts, in the sense that they were constituted on the basis of Chapter 3 or on the basis of Section 51. Because if a body is constituted according to Section 51, then it is possible that while that body or board may act judicially, it actually does not have to. So in other words, it may be that that body or board or tribunal may actually dispense with the rules of natural justice, depending on the way that the Parliament would enact the legislation. It's also possible that in creating a body or tribunal that seems to act judicially, it is possible that because that agency or body or tribunal, because it forms part of the executive, it therefore is not fully insulated from political pressure or political influence. So for that reason, again, there is a need to determine whether such a tribunal or body or agency or court, even if it is called a court, there is a need to determine whether that body or agency is a Chapter 3 court or not, and whether or not it is exercising judicial powers or non-judicial powers. And this discussion of ours, obviously, at this point, is only relevant in relation to federal courts, because, as we pointed out previously, there is really no separation of powers in state courts, which means, therefore, that it is permissible for state courts to be vested with non-judicial functions. So in which case, for example, they may do investigations, or they may even prepare reports on behalf of government ministers and so on, which are non-judicial functions, obviously. So let's go deeper into this notion. So we begin by so if we need to talk about, if we need to make a distinction between judicial and non-judicial power, we need to then first determine what judicial power is. And a classic formulation of judicial power was enunciated by Chief Justice Griffith in the case of Huddart Parker and Company Proprietary Limited versus Moorhead in 1909, where he defined it as the power which every sovereign must of necessity have to decide controversies between its subjects or between itself and its subjects, whether the rights relate to life, liberty, or property. The exercise of this power does not begin until some tribunal, which has the power to give a binding and authoritative decision, is called upon to take action. So there are three aspects to when judicial power can be said to exist. And the first is that there must be a controversy between its subjects or between itself, the state, and its subjects. Secondly, there must be a controversy about rights, whether that controversy is about life, liberty, or property. And thirdly, there must be a tribunal which has a power to give a binding and authoritative decision. Now, it needs to be emphasized that these three elements of when a judicial power is said to exist actually relates to the power of federal courts to only decide when there is a matter before it. So if you look at Section 75 and of the Australian Constitution, it is clear that the jurisdiction of the High Court, for example, can only be triggered or can only be exercised when there is a matter before it. So there is the concept of a matter, and matter has been defined as having the three elements which were enunciated or articulated in the case of Huddart Parker versus Moorhead. Now, what do we mean by a controversy? What this actually means is that there must be a dispute or differences between two people at least. So in other words, if an agency of government, whether it's called a tribunal or a court, has the power on its own to kind of investigate persons or to kind of summon persons to come before it to explain why something needs to be done or to impose a fine if they don't appear. In other words, there is no dispute, but the court, a tribunal or a court on its own has the power to initiate a proceeding. Then in that case, it is clear that there is no controversy. And if that be the case, if there is no controversy, then there is no matter before that tribunal or before that court. And because there is no matter before that agency of the government, it must mean in that case that there is no instance where judicial power can be exercised. So this also means that judicial power the exercise of judicial power cannot be permitted in an instance where there is a request, for example, for a hypothetical opinion or a theoretical opinion or an advisory opinion. That will not be permitted in the sense that does not involve a matter. So somebody cannot come before a federal court or a Chapter 3 court asking for a theoretical opinion or an advisory opinion. And as we remember in the previous weeks, we had an instance of the events prior to the dismissal of former Prime Minister Gough Whitlam, where the former Governor General John Kerr came before the Chief Justice of the High Court to ask for an advisory opinion on the constitutionality or the validity of him exercising his power to dismiss a Prime Minister. But that was an unusual scenario whereby the Chief Justice of the High Court gave his advisory opinion. Although, again, in the context of the very unusual scenario or setting in Australia at that time, the Chief Justice of the High Court provided an advisory opinion, but that would not have been in the exercise of a judicial power. So judicial power can only be exercised if there is a controversy. And a controversy, in that case, can only, the power of the court, therefore, the power of a Chapter 3 court, therefore, can only be invoked when there is a proceeding before it, where a suit has been filed or an action has been filed before it involving parties. So it cannot go on its own, as I said, to try to initiate a proceeding or summon a person when there is no action before it. Secondly, the controversy must involve rights, whether it relates to life, liberty, or property. And what this essentially means is that in speaking of rights, liberty, or property, the purpose of judicial power is to ensure that it determines pre-existing rights between party litigants. So a court will therefore apply the law according to the rights between the parties. It adjudicates the existing rights of parties. It does not go about creating new rights or modifying new rights. Modifying rights of people, for example, appearing before it. In the case of administrative tribunals, or in the case of non-Chapter 3 courts, where there are proceedings before it, it is very permissible for those tribunals to create new rights or even modify existing rights. But in relation to the exercise of power, the controversy must pertain to existing rights, and it is the duty of Chapter 3 courts to make an adjudication as to what the rights are between the parties. And those rights relate to life, liberty, or property. And so in that case, the giving of decisions will be in the nature of an adjudication of a dispute as to rights or obligations arising from the operation of a law upon past events or conduct. If we go by a statement by Justice Dean in Polyukhovich versus Commonwealth, for example, he said, citing the case of Rowlock Company, Proprietary Limited versus the Commonwealth, he said that a judicial inquiry investigates, declares, and enforces liabilities as they stand on present or past facts and under law supposed already to exist. Now, thirdly, the other aspect of judicial power is that it only occurs when a tribunal or a court is given the power to give a binding and authoritative decision. That is, again, one hallmark of a Chapter 3 court, because its decision is binding and authoritative. What this essentially means is that its decision, for example, constitutes as res judicata between the parties. So in other words, once a decision has been reached by the court concerning a case between parties, those parties are bound by that decision, and they are not permitted to reopen that decision at some point, because that is conclusive and authoritative as between them. It also, unless they go on appeal. It also means that that decision cannot be subjected to a collateral attack. So in other words, for a decision issued by a court to be attacked, it must be in a direct proceeding, such as an appeal. If there were to be another suit or action involving a totally different subject matter, and there is an attempt to question the validity of a previous decision, that will be impermissible because that will constitute a collateral attack. On the other hand, it is the quality of a decision made by a non-Chapter 3 court that its decision is not binding and authoritative, in the sense that that decision can actually be changed or modified or even altered or reversed by another tribunal which is not part of a Chapter 3 court, which is not a Chapter 3 court. And it is not possible for a tribunal to say that its decision is authoritative, in the sense that it is always up to a Chapter 3 court to make a final decision on a particular case or suit. So moving on, as we said, we speak of the distinction between judicial and non-judicial powers mainly because there exist non-Chapter 3 courts, or what we call as quasi-judicial tribunals. And a good example of this would be the Administrative Appeals Tribunal, which was created by Parliament under the Administrative Appeals Tribunal Act of 1975 Commonwealth. So the AAT is not a Chapter 3 court. And in fact, its members, not all its members are judges, in the sense that a lot of them are laymen, some of them are economists, some of them may be businessmen, some of them may be social workers, some of them may be engineers, some of them may be contractors. Whereas, as we know, the only persons who can be part of Chapter 3 courts must be persons with a legal background. But that is not true with a Chapter 3, with a non-Chapter 3 court, such as the AAT. The other point that needs to be made is that non-Chapter 3 courts belong to the executive. They form part of the executive. The AAT, for example, is within the portfolio of the Attorney General of the Commonwealth. And because they form part of the executive, when they make decisions not solely according to the law. They may make decisions according to policy, meaning government policy and whatever the agenda might be of the executive or the legislature. And they may also exercise discretion. In other words, there may be a template or a set of guidelines that they follow in making a decision which is not strictly within what the law may say. So there is an opportunity for them to exercise their discretion in making their decisions. Now, although, for example, many quasi-judicial tribunals such as the AAT act judicially, in the sense, as I said, that they need to be impartial and fair, and that they need to give persons that appear before them the opportunity to be heard, quasi-judicial tribunals are not necessarily required to act judicially. So in other words, there may be times when a quasi-judicial tribunal may forego with the requirement that they give persons before them an opportunity to be heard. So in fact, it may go on a process of trying to do an investigation on its own, trying to secure facts without informing the other party. And it also means that in certain cases, it may be permitted to actually favor certain persons or certain individuals as a matter of government policy. And so therefore, it may favor, for example, persons who may have problems with financial means or may have limited educational backgrounds. And for that reason, it discriminates in favor of these persons. But Chapter 3 courts, on the other hand, must at all times act judicially, in the sense that they must always be impartial and objective, and they must always give persons appearing before them the opportunity to be heard. It is also necessary to point out that it is a quality of quasi-judicial tribunals to unilaterally and coercively change legal relations. So In the context, for example, of issuance of licenses, it is possible that a quasi-judicial tribunal may end up deciding not to issue it, or may end up revoking it, or even suspending a license on its own without a party complaining before it, without there being a suit or action between parties. So a quasi-judicial tribunal on its own may do this. A Chapter 3 court, on the other hand, we will remember, can only act when there is an action before it, when there is a suit before it. So a Chapter 3 court cannot unilaterally change legal relations between two persons, for example, unless there is a suit before it. But that is a power that quasi-judicial tribunals have. So we've already mentioned here that quasi-judicial means also that there is a permissible use of wide discretion. So which means that they may decide according to what is fair and just. They may decide according to a manner that they seem fit, or they may decide according to what they regard to be convenient, or according to what they regard to be just. Whereas the formulation of decisions by Chapter 3 courts is always according to the law. So, how do we determine, for example, that whether or not a tribunal or a court is a Chapter 3 court or not? So we always go to that question of whether or not it is exercising a judicial power, because, as we said, under Chapter 3 of the Constitution, for example, in Section 75 of the Australian Constitution, the power of the High Court can only be invoked when there is a matter before it. And as we said, there is a requirement that there must be an actual controversy between persons, and that controversy must involve pre-existing rights relating to life, liberty, or property, and that court must be in a position to make a final, binding, and conclusive decision. In contrast, if we look at non-Chapter 3 courts that obviously exercise non-judicial powers, as I said, they can make a determination without observing procedural fairness, meaning they are not required to give parties an opportunity to be heard. They may even dispense with the need to act judicially. They are given broad discretion in their decisions, and they adjudicate using broad standards such as adequate, proper, reasonable, right and fair, or good conscience. And they may deal with non-matters or instances where there is actually no controversy. In other words, on their own, they may initiate a proceeding, for example, to revoke a license of a person, or summon a person to give it, depending on what the law says, summon a company, for example, to present its financial documents. In fact, one of the first cases where the issue of non-judicial powers came was, as I pointed out, the case of Haddard Parker versus Moorhead, where the question was raised whether or not the power of the Comptroller General of Customs to require a company to submit before it certain documents and reports, and with the power to impose a fine upon companies that fail to do so, whether or not that involved the exercise of judicial power. So that was essentially the question in Haddard Parker Company Proprietary Limited versus Moorhead. And the High Court decided that in that specific instance, non-judicial power was involved. It did not involve the exercise of judicial powers, mainly because when the Comptroller General of Customs sought to compel, according to legislation, companies to submit documents before it, it was clear that there was no controversy involved. And the decisions of the Controller General were not authoritative and binding in that sense that they were always subject to review by a court. There was also the case of Alberan versus Board of Liquidators, and the question there was whether or not the Board of Liquidators, which had the power to suspend or revoke license of persons who were given the license to become liquidators, whether or not that power to revoke or suspend licenses was in the exercise of judicial powers. And the court said that it was not, because all that the board did was actually to determine whether or not a person who was seeking to have a license as a liquidator or who wanted to continue to have a license as a liquidator actually met the requirements of being a liquidator. So that was the focus of the Board of Liquidators. And it was also clear in that case that even in the absence of an actual suit between parties, or even in the absence of a legal proceeding, the Board of Liquidators on its own initiative could determine whether or not a party or a person had the requirements of being a liquidator, and if that person did not, then that person may lose his or her license or have his or her license suspended. And again, those would indicate that that is not a Chapter 3 court, because a Chapter 3 court can only act when there is a matter before it or there's an actual controversy before it. In addition, a non-Chapter 3 court, as I mentioned, also is able to act unilaterally or coercively and adjudicate on its own initiative. So in that case, even if there is no complaint, even if there is no suit or proceeding before it, a non-Chapter 3 court, or for example, an administrative tribunal, may unilaterally compel a party or person, according to law, to come before it to explain certain things or to provide certain documents, or for that administrative tribunal, for example, to undertake an investigation on its own without there being a suit or action between persons. A non-Chapter 3 court can also create new legal relations or rights, in the sense that depending on, for example, government objectives or government policies or whatever policies might be there, it may then decide to alter the current rights of certain persons so that there would then be a new legal relation or a new right that is created as a result. Non-judicial or non-Chapter 3 courts can also make decisions without regard to technicalities or legal forms. So they can dispense with rules of evidence. They can make proceedings as informal as they could, whereas Chapter 3 courts must always proceed on the basis of certain legal rules and on the basis of the rules of evidence. Non-Chapter 3 courts are also permitted to decide on the basis of what can be or what is in the public interest, as well as on the basis of policy, whereas Chapter 3 courts decide solely on the basis of what the law decides and are not permitted to take into account government policy and what the public interest is, because the focus of an adjudication by the Chapter 3 courts is only to look into the actual controversy between the parties and for the court to make a resolution according to the pre-existing rights of the parties before it, irrespective of what the implications may be of the decision that affects solely the parties appearing before it. Now, there are ways by which we can actually determine whether or not a court or a tribunal, so when we speak of a tribunal, we're mainly referring to a non-Chapter 3 court. There are ways by which we can determine whether an agency of government is a Chapter 3 court or not. and that depends on the nature of the agency exercising the power. We can also look at its jurisdiction, meaning whether or not it falls within the ambit of its power to decide a specific action. We can also look at the basis of the decision as well as the effect of the decision. So let's look at the details. When we look at the court or agency or tribunal that exercises the power, a Chapter 3 court, in relation to that type of judges, the judges in Chapter 3 courts are those that are appointed according to the strict guidelines or the strict provision of Section 72 of the Australian Constitution. And this essentially means that they are judges and that they have a legal background. On the other hand, as to membership in non-Chapter 3 courts, there is no limitation because you can have dentists, assessors, engineers, contractors, or businessmen, or even pilots as part of a non-Chapter 3 court. In terms of the appointment of members of Chapter 3 courts can only be done by the Governor General in Council, whereas it is the executive department that would appoint members of a non-Chapter 3 court. Chapter 3 court judges have security of tenure, whereas members of tribunals or bodies don't have security of tenure, in the sense that it is possible that the Parliament, for example, may change the qualifications of members of a tribunal, or they may decide to reduce the number of years of service of a person that forms part of a non-Chapter 3 court. Whereas, as far as membership in a Chapter 3 court, the judges there have security of tenure, and for as long as they do not reach the age of 70, judges can continue in the appointment of justices of the High Court, for example, they can continue to stay in office up to the age of 70. In terms of the removal of judges, if we speak of a judge of the Chapter 3 court, a judge can only be removed through an address from Parliament by a Governor General in Council. So as you can just imagine, that will require a difficult process because it has to be an address with the Governor General in Council before Parliament. Whereas the removal of judges can be made by the executive department. In terms of grounds of removal, the Constitution is clear that it can only be based on misbehavior or incapacity, whereas the grounds for removal of members of non-Chapter 3 courts can be broader because they are based on statute. And so it could be beyond the grounds for removal can go beyond just misbehavior or incapacity. It can involve such issues as conflicts of interest, or it can be that a ground of removal may be questions of propriety or issues of lack of confidence in the members of the tribunal, and so on. In terms of remuneration, the remuneration of Chapter 3 judges cannot be diminished, whereas the remuneration of members of a tribunal can be reduced because it is within the power of the Parliament to change the legislation in the first place, which created the tribunal. So as part of its power to create the tribunal, the Parliament would also have the power to change the provisions of that enactment, which can involve changes in the requirements of membership in a tribunal and also in relation to remuneration of the members serving therein. In addition, Chapter 3 courts actually may exercise non-judicial powers which are incidental to the exercise of judicial powers. So there are instances when a court itself is exercising non-judicial functions. And for example, this may be when a court may decide, or the court may decide to come up with guidelines or rules or procedure relating to practice or relating to the way that evidence should be examined by judges of the courts. And as we said, the power to make rules or guidelines or laws are typically belong to the legislature. But in this instance, it is within the power of Parliament it is within the power of the courts to make guidelines that would assist it in matters of evidence or in matters of procedure of cases appearing before it. In addition, assuming, for example, that there was a previous action involving a corporation, and assuming that a matter has already been decided by a Chapter 3 court, it is still permissible for a judge to compel the examination of persons or of documents if that specific company is then sought to be liquidated or winded down. So in that case, that power of compelling an examination of the affairs of the company or to examine documents or to examine witnesses is non-judicial, but still it would be a valid exercise of judicial power as an incident to the exercise of judicial powers. On the other hand, if we speak of non-Chapter 3 courts, they obviously typically exercise quasi-judicial and non-judicial functions. So it's quite likely that a tribunal, a non-Chapter 3 court, for example, may conduct proceedings on its own, even in the absence of parties. It may even make reports, provide hypothetical opinions, advisory opinions, and so on, as part of its mandate in having been created. In terms of which part of the government it belongs to, a Chapter 3 court is part of the federal judiciary, whereas a non-Chapter 3 court is part of the executive branch. In terms of jurisdiction, the source of jurisdiction of Chapter 3 courts is obviously constitutional, and that is Chapter 3 of the Constitution, whereas typically non-Chapter 3 courts are created on the basis of an Act of Parliament, of the Commonwealth Parliament, although the power of the Act of Parliament to create such tribunals emanates from the Constitution in the sense that it must be authorized by Section 51, meaning it must be one of those subjects or heads of power under which the Commonwealth Parliament is able to act. But we will notice that in that specific case, the creation of a tribunal itself is based on an Act of Parliament and not based on the Constitution. In terms of the basis of jurisdiction, the jurisdiction of Chapter 3 courts can only be invoked when there is an actual controversy, whereas the jurisdiction of non-Chapter 3 courts is unilateral. So in other words, it can act on its own, and it is also coercive because even in the absence of a proceeding or a dispute before it, a non-Chapter 3 court can compel persons or companies to come before it, like to produce documents or to be examined. Now, in terms of the basis of a decision, if it's a Chapter 3 court, the Chapter 3 court adjudicates on the basis of existing rights. The basis of decisions, on the other hand, of non-Chapter 3 courts is future rights. In other words, non-Chapter 3 courts seek to create typically new legal relations or new standards. And so, in other words, even the main purpose, for example, why a person may come before a non-Chapter 3 court is in fact to ask that new legal relations be created or that new rights be created as a result of coming before the tribunal. So in this case, there may be a request or a desire for higher entitlements according to, let's say, child support or according to welfare benefits given by the government. As far as Chapter 3 courts are concerned, in terms of making a decision, they must always observe procedural fairness. In other words, they must always give persons an opportunity to be heard. The persons appearing before, they must always be given an opportunity to be heard. And this also means that the decisions of Chapter 3 courts must always be according to the evidence before it. Non-Chapter 3 courts, on the other hand, do not have to comply with procedural fairness. So they may decide not to give persons any opportunity to be heard. The non-Chapter 3 court could conduct an investigation on its own. It may be possible for a non-Chapter 3 court not to provide a reason for its decisions. Its reasons also may not be based solely on evidence. The decision may be based, for example, on policies or broad discretions given to it by the enacting law. In terms of the basis of the decision, the decision of Chapter 3 courts is always based on the law. So it always makes a decision according to legality or what the law provides. On the other hand, the basis of decisions of non-Chapter 3 courts would be broader because it can be based on law, on policy, discretion, and even political considerations. Judges of Chapter 3 courts are not permitted to use their discretion, whereas typically non-Chapter 3 courts can use their discretion in making in arriving at their decision. So when we say that they can use their discretion, they can make decisions according to what they feel is just, according to the case, or what they deem to be fit, to be according to policy or according to political considerations. So in that case, discretion is permissible in the case of decisions made by non-Chapter 3 courts. The decisions of Chapter 3 courts are binding and conclusive in the sense that unless a decision made by a Chapter 3 court is not appealed, it then becomes a final judgment that is enforceable. Whereas a decision of a non-Chapter 3 court is not binding and non-conclusive in the sense that it is always subject to review by a court, or even by another tribunal that may have a higher standing than the original tribunal that made the decision. In terms of precedent, the decisions of Chapter 3 courts always have the nature of stare decisis. In other words, judges make decisions according to precedents before it. So in a sense, judges are bound by decisions previously made by other judges, assuming that that is a decision of a superior court or of a higher court. So they are not permitted to deviate, assuming that the facts of the case are similar to previous decisions. Then Chapter 3 judges are not permitted to deviate from legal principles enunciated in previous decisions. Whereas there is no precedent in decisions of non-Chapter 3 courts. So because, for example, of the wide policy discretions given to non-Chapter 3 decision makers, they may decide that the previous decision arrived at by a decision maker will be altered or changed, even if the facts may almost be similar. So there's no such thing as a stare decisis. In terms of the applicability of the doctrine, the decisions made by a Chapter 3 court have general applicability in the sense that they can be made to apply the legal principles enunciated in a decision of a Chapter 3 court applies to similar cases, whereas the decisions made in a non-Chapter 3 court apply only to a specific case. let's see. So we've covered that so far. The judiciary, as we saw earlier, we saw that the judiciary was quite happy to welcome a blurring of the lines between the executive and the legislative divide, so that it is even permissible for the legislature to authorize Parliament to pass subordinate legislation, so making them quasi-legislative. And we also saw that it is permissible for the executive to have exercise quasi-judicial powers. Now, however, in relation to judicial powers, meaning the powers exercised by, and we're speaking, remember, of the federal courts here, the judicial power, the High Court has clearly pointed out, it can only be vested in. So we're speaking of federal judicial power. Federal judicial powers can only be vested in what are known as Chapter 3 courts. So the High Court will not tolerate the exercise of a judicial power by the executive or by the legislature. So in other words, if there seems to be an administrative tribunal or an administrative agency, meaning administrative in the sense that they are part of the executive department, if these tribunals or agencies attempt to exercise judicial power, that will be deemed to be invalid and unconstitutional. So when there is an administrative agency, for example, under the executive department that seeks to govern an actual controversy between parties or the exercise of judicial power in that regard, that will be struck down by the federal judiciary as being unconstitutional and invalid. Now, the other aspect that the High Court has been very guarded in is in relation to the authorization or the vesting of non-judicial powers on Chapter 3 courts. So while the High Court has recognized that it is okay for the legislature to vest quasi-legislative powers in the executive, the High Court will not tolerate the vesting of quasi-legislative powers on the judiciary. It will not allow that. And so on those two aspects, the judiciary has been quite guarded. And one of the first cases that is crucial in this regard is the case of Victorian Stevedoring and General Contracting Company Proprietary Limited versus Dignan, or Dignan's case, which we earlier cited, where the High Court said, and specifically Justice Dixon said, because of the distribution of the functions of government and of the manner in which the Constitution describes the tribunals to be invested with the judicial power of the Commonwealth and defines the judicial power to be invested in them, the Parliament is restrained from both reposing any power essentially judicial in any other organ or body and from reposing any other than that judicial power in such tribunals. The High Court also stated in R versus Kirby, or the Boilermakers case, that the existence and the constitution of Chapter 3 and the nature of the provisions it contains makes it clear that no resort can be made to judicial power except under or in conformity with Section 71 to 80. And Section 51, subsection 39, also extends to furnishing courts with authorities incidental to the performance of the functions derived under or from Chapter 3, and no doubt to dealing in other ways with matters incidental to the execution of the powers given by the Constitution to the federal judicature. So in the Boilermakers case, what it essentially means is that the judicial power includes incidental powers that may not be specifically provided in the Constitution. And the High Court also said that for that reason, it is beyond the competence of the Parliament to invest with any part of the judicial power, any body or person, except in a court created pursuant to Section 71 and constituted in accordance with Section 72, or a court brought into existence by a state.
Um, and then I'll speak shortly about I'll speak shortly about how it is in the states. So judicial power has two key elements. One is that there must be an actual controversy involving rights to life, liberty, or property. So, in other words, if there is no actual controversy, in other words, if it involves something that's hypothetical or theoretical or a potential scenario, the judicial power cannot be invoked. So, judicial power can only be invoked when there is an actual controversy involving rights to life, liberty, or property. Um, I, it's important to emphasize this as well because if you remember in the previous week, we talked about the case of the dismissal of the government of Prime Minister, the government of the former Prime Minister Gough Whitlam by former Governor General Sir John Kerr. And in his letter dismissing the Gough Whitlam government, uh, former Governor Sir John Kerr said that he was acting actually on the advice of the former Chief Justice of the High Court. I think, if I'm not mistaken, it was Chief Justice Barwick, who said that the Governor General had residual powers to dismiss a Prime Minister who refused to resign even when he had lost the confidence of Parliament, or who refused to resign even when he was unable uh, to pass supply legislation. And he had actually cited former Governor General Sir John Kerr had actually cited the the advisory opinion of Chief Justice Barwick in that regard, in saying that in those instances when a prime minister loses the support of parliament or is unable to pass supply legislation, the prime minister in that regard has only two possible choices. One is either to resign or to call for general elections. And in those tumultuous years of the on those in 1974 and 1975, the former prime minister then Gough Whitlam had said that he was neither going to resign and neither was he going to call for general elections. And Chief Justice Barwick of the High Court said that it was within the power of the Governor General, the inherent or residual powers of the executive of the Governor General, to dismiss the Prime Minister. So that was an advisory opinion. And it is clear that if you follow Huddart Parker and Company Proprietary Limited versus Moorhead, the High Court has clearly, the High Court itself, the court itself, not just the Chief Justice or not just a single justice, the High Court has pointed out that the exercise of judicial power can only be made when there is an actual controversy. The High Court cannot provide a hypothetical opinion or cannot try to adjudicate or provide a decision on the basis of a theoretical controversy, which wasn't the case because there was an advisory opinion provided by Chief Justice Barwick. But again, that was in the context of the difficult years of 1974 and 1975. And I don't think that there was ever, well, although Sir John Kerr relied on it, there was never any attempt to say that the advisory opinion was ever binding. It was meant to be actually advisory. But again, in general, it is not for the judiciary to provide advisory opinion. Secondly, the other aspect of the exercise of judicial power is that the power must be the exercise of the judicial power must be binding, and it must be authoritative. Binding in the sense that it actually compels the performance by those involved uh, in a controversy, that they must do or not do certain things. And it is authoritative in the sense that it actually binds and is conclusive uh, in relation to the matter or subject that is the basis of a controversy. When you speak later on, when you speak of being authoritative, it doesn't mean, or when you speak of it being binding or conclusive, it doesn't mean that a decision made, for example, by the Federal Circuit Court becomes final. It can actually be subject to appeal, whether to the federal court or to the high court. But it is binding, at least in the sense that if there is no other remedy that that is sought to uh, be followed by parties in a controversy, then that decision then becomes the final decision and is binding. Okay, now the other crucial point that we need to cover when we speak of the judicial power is the notion of the persona designata. And this essentially means that what about those instances where Parliament passes legislation whereby a member of the judiciary or a member of the Chapter 3 court is asked to undertake acts that are not judicial in character, meaning the member of the judiciary may be asked to do certain executive functions or administrative functions or even legislative functions, in the sense that a member of the judiciary or a member of the Chapter 3 court may be asked to create reports for the executive or for the legislature, or they may be asked to serve in administrative tribunals, tribunals that are not Chapter 3 courts and that are in fact part of the executive. Will there be something invalid or unconstitutional in that? Because we already said that the High Court has always been very guarded about the exercise of judicial powers, and the High Court has clearly said that no Chapter 3 court can be invested with non-judicial powers by the legislature or by the executive, and the Chapter 3 courts can only exercise judicial powers. That has been clear. So what then do we make of instances when the legislature says that a member of the judiciary or of a Chapter 3 court or of a federal court can exercise certain legislative powers or quasi-legislative powers or quasi-executive powers, or serve in a tribunal that is not a Chapter 3 court? Would that be unconstitutional? And the answer is no, if certain conditions are met. And the idea of persona designata was recognized in the case of Drake versus Minister for Immigration and Ethnic Affairs, where the High Court said that there is nothing in the Constitution which would preclude a justice of the High Court or a judge of this or any other court created by the Parliament under Chapter 3 of the Constitution from, in his personal capacity, being appointed to an office involving the performance of administrative or executive functions, including functions which are quasi-judicial in their nature. Such an appointment does not involve any impermissible attempt to confer upon a Chapter 3 court functions which are antithetical to the exercise of judicial power. Indeed, it does not involve the conferring of any functions at all on such a court. So, in the case of Drake versus Minister of Immigration and Ethnic Affairs, the High Court said that it is permissible for a person, for a judge of who is part of the federal court, to exercise administrative functions for as long as that exercise is the exercise of by him or her as a person and not acting as a part of the court. That is permissible. And the case of Grollo versus Palmer and Huddard Parker and Company Proprietary Limited versus Moorhead also establish the requirement that the only time when a federal judge or a member of a Chapter 3 court can exercise quasi legislative or quasi executive powers must be based on two conditions being met. One is that there must be consent on the part of the federal judge. So if the federal judge refuses, he cannot be forced to do or to exercise quasi-judicial or quasi-legislative or quasi-executive powers. He cannot be forced. But if he agrees, then that is fine. And that is the reason why we will notice that the head of the Administrative Appeals Tribunal under the Administrative Appeals Tribunal Act 1975 Commonwealth, the head of that tribunal, of that administrative body, is actually must have to be a member of the Federal Court of Australia. It's a requirement. So, but that is based on the consent. The federal judge must consent. And secondly, it is crucial for a person, for a federal judge who is undertaking quasi-legislative or quasi-executive or quasi-judicial functions, that the performance of those tasks must not be incompatible with the exercise of his judicial duties. In other words, at the very least, a federal judge exercising non-judicial powers, number one, must not be beholden to the executive. So in other words, the federal judge must still be able to exercise independence. He cannot become an instrument or a tool of the executive. He cannot act at the behest of the executive, because otherwise that will put into disrepute or put into question the independence of the judiciary. That will not be allowed by the High Court. The second aspect of it is that the federal judge who is exercising non-judicial powers on the basis of persona designata cannot become involved in the sense that he tries to play favorites with the executive, in the sense that his action, he only acts on the basis of trying to please the executive because of the possibility that he may lose certain emoluments or certain benefits given by the executive. In that case, if he does so, that again will be incompatible with his judicial role. And in the case of Grollo versus Palmer, and I'd like to read the statements by Chief Justice Brennan and Justices Dean, Dawson, and Toohey. The incompatibility condition may arise in a number of different ways. Incompatibility might consist in so permanent and complete a commitment to the performance of non-judicial functions by a judge that the further performance of substantial judicial functions by the judge is not practicable. It might also consist in the performance of non-judicial functions of such a nature that the capacity of the judge to perform his or her judicial functions with integrity is compromised or impaired, or it might consist in the performance of non-judicial functions of such a nature that public confidence in the integrity of the judiciary as an institution or in the capacity of any individual judge to perform his or her judicial functions with integrity is